Design Build, Risk Management, Kent Holland, ConstructionRisk LLC, Lesson 2, Joint Ventures and Teaming Agreements. When dealing with design build projects, groups will often come together as a contractor and a designer to create a special purpose entity to perform the work. And the special purpose entity might be a joint venture, it might be a limited liability company. First, I'm just going to deal with joint ventures. It's viewed as a partnership. The parties will share losses and profits. There will be a management committee, and a very significant aspect is there will be joint and several liability at law, so that each party is responsible for their own actions, but also jointly severally liable 100% for the actions of their partner. So to the extent that the partner does not have insurance or does not have sufficient assets to pay a claim, then the joint venture partner may end up liable at law for the whole 100% of the damages awarded to the project owner or a third party claimant. The limited liability company, the LLC, it's a statutory creation. You need to look at each individual state to determine the requirements. There will be member management, there will be managing members, management committees, things very similar to what you had in a JV agreement or teaming agreement between the partners, and this will go into the agreement that created the LLC. It's treated as a partnership for taxation purposes. You will have, because of its nature as a limited liability company, you'll have limited liability of the individual member firms. Again, there will be a fiduciary relationship of the managing members. Issues to consider before using a special purpose entity include the following. First, joint venturers. The parties can assume unintended liability, and this question is often asked of me and others in the legal community or who address insurance related issues, is what insurance coverage am I going to have if liability is imposed upon me for damages not caused by my firm, but rather my joint venture partner's firm? Well, that becomes a very tricky issue, and tune in for the insurance segment of this presentation to deal more with that issue. In an LLC, the owner has a problem in that it may be contracting with a shell company that does not in itself have assets. There could be licensing issues. Does the LLC live off of the licenses of its members who are both licensed with the state and that is adequate, or does the LLC itself need to get any kind of a state license? And then there are bonding and insurance issues. The LLC, as a new entity, one that doesn't have its own assets, is logically not going to be able to get bonding, so it may have to rely upon its joint venture members to get those bonds. Insurance. Will the LLC get its own policy for a project, or will it again rely on the policies of its individual members? These are all issues to be considered and addressed. There is generally going to be a teaming agreement that is going to determine, resolve, if you will, how the parties that are coming together to do the joint venture will team together. And that agreement is going to be between the members of the team, the designer and the contractor builder. It has legal consequences. It's an organizational structure that is created. It will deal with the proposal preparation cost. It's going to deal with post-award considerations. It will deal with things like confidentiality of the parties and their documentation. It will deal with things like ownership and copyright of the documents that are provided by each of the team members. It may deal with post-award considerations or considerations on competing with each other. And in the event that the award isn't granted, may the member then work with another successful proposer. And then the agreement has to deal with termination of the agreement itself. Now, let's look generally. What are teaming agreements? They are agreements that are frequently used by government contractors that have complementary capabilities and intend to propose or work on a prime contractor subcontractor basis. The agreements reflect the parties' intent that if the government awards a contract to the prime contractor, well then the prime will enter into a subcontract with another team member. And the teaming agreement often will allocate the types and amounts of work to be done by each party of the team. And also the profits and losses that each party will take. It'll also have how the team overall is going to be managed. Now, one of the reasons that teaming agreements are used is that they avoid the need for parties to negotiate a detailed subcontract agreement that they may end up not needing if their proposal is not successful. And it can take a lot of effort and time to negotiate a subcontract. So this might potentially be put off to a later day by virtue of having the teaming agreement in place instead. Now, there are a lot of interesting issues that arise out of teaming agreements, including are they enforceable? Or is it really an illusory agreement, or is it really a binding agreement? And I'm going to show you a few cases that deal with that issue. Questions to ask before the teaming agreement is executed. What type of project is at issue? Who should be on the team? We look at the design-build experience of the different members and see what they all bring to the table. What are their strengths and weaknesses? And do they communicate well with each other? Do they know each other well? One of the huge issues in design-build risk management is needing to know, understand, and trust the joint venture partner who's going to be part of your team. This is like a marriage. This is not to be handled as a typical design contractor relationship where there may be not so much trust and more antagonism between the parties. I see more cases where the problems occur because the contractor and the designer do not have a long history of working together, and they treat each other as adversaries. They don't trust each other, they don't work well together, their teams don't coordinate well together, they don't communicate and resolve issues quickly and easily. It's really important to get a teaming arrangement with parties that work well together and know each other. Let's look at the elements of the teaming agreement. First, we establish who will be the members of the team. And you'll have the contractor, the designer, maybe key subcontractors. You'll have a non-competition confidentiality clauses. There will be disclosure and ownership of proprietary information. How are you going to deal with that? How are you going to protect that from your joint venture's partner possibly taking that and using it? And we need to have dispute resolution set forth in the teaming agreement so that if there are disputes between us, how do we resolve those disputes? There should be provisions dealing with sharing of cost. How are we going to dedicate personnel and resources to the team? Review of proposal prior to submission. Who's going to be responsible? Who's going to pay for it? Who's going to take the lead on it? The cost and financial terms prior to submission. How are we going to share those? And then in the event that we don't get the award, there often is going to be an honorarium or a stipend given by the project owner, particularly if it's a government. And these can be rather significant stipends, but usually they don't even begin to approach paying for the proposal preparation costs, which included all the design work that may have gone into that initial proposal. Well, you get that stipend. How is it going to be split between the parties? The teaming agreement can address that as well, or it should address that. Some of the considerations for the relationship that are going to be set forth in the teaming agreement include the structure of the design-build entity, how is it going to be organized and operated, what's the percentage of ownership between the parties, how do you divide up the profits and losses, the preparation of a matrix really of responsibilities should be there. Responsibility for negotiating the prime contract terms, who's going to take the lead in doing that? And then it may be necessary under various state law that it establish the subcontract forms or even the terms and conditions, perhaps even requiring that a subcontract be attached to the teaming agreement saying this is going to be the subcontract in the event that we get the agreement. Because you'll see under Some state law, including Virginia, the courts do not look favorably on a teaming agreement where there's not a subcontract because they see it as an agreement to agree in the future. They don't see it as a binding agreement right now. So agreements to agree are generally deemed unenforceable. Other things that can be addressed in the teaming agreement include establishing a process for coordinating the design with the construction budget, design development processes and sharing of information should be reviewed and considered in this. Establish the contingencies and what incentives will there be for the designer, and is there going to be a limitation of liability for the designer. Let's look now at a case study or two. The first case I'm going to address is called ADEX Corporation versus Transworld Communications, and here a subconsultant contributed significantly to obtaining the design-build contract. And the court found that there was an enforceable teaming agreement, meaning that this company was going to be entitled to participate. However, the court only granted relief that was limited to the amount spent in the solicitation effort and the, quote, fair value of the subcontractor's contribution to the prime contractor's agreement, close quote. The court did not give lost profits. It said that was too speculative. So here it was almost treated like a termination for convenience, that the prime was permitted to terminate its subcontractor, but it had to pay the subcontractor this limited relief according to the court. Next case is Trident Construction versus the Austin Company. And in this one, there were preliminary discussions between Trident, who was a subcontractor, and the Austin Company, who was going to be the general contractor, but they couldn't agree on a price. And they had an agreement, but the court found this to be an agreement to agree and said that this was not enforceable. And the court says, quote, where a contract does not fix a definite price, there must be a definite method for ascertaining it, close quote. Well, this particular agreement didn't have that kind of method for ascertaining the final price, therefore the court said this is an unenforceable contract. A most recent case, 2013 case, called CyberLock Consulting versus Information Experts out of the United States District Court in Virginia, held that a teaming agreement between two contractors was unenforceable under Virginia law. Now this really raises questions about the whole usefulness of these commonly employed agreements. The court granted summary judgment to Information Experts, the firm, which was resisting the enforcement of a teaming agreement by CyberLock after the parties were unable to reach agreement on a subcontract relating to the prime contract that was awarded to Information Experts by the federal government. And the court essentially agreed that the teaming agreement was, quote, a mere agreement to agree in the future, close quote, and therefore unenforceable under Virginia law. The court noted that unlike an earlier teaming agreement between the same parties, this one didn't include a detailed description of the work that was going to be performed by the proposed sub, and it didn't include as an exhibit the subcontract that the parties would execute in the event that the agreement was ultimately awarded by the government. The court also noted that the teaming agreement included a provision calling for termination of the agreement if there was, quote, a failure of the parties to reach agreement on a subcontract after a reasonable period of good faith negotiations, close quote. So this looked to the court like they almost anticipated that maybe they wouldn't ever end up in a contractual relationship because they might not agree. So the court again was looking at this saying, well, you agreed to agree, but you didn't really agree on the contract. The bottom line, to avoid the potential that a court will not enforce the teaming agreement, would appear to be that you should have an agreement in place as to what your subcontract will actually be in the event that the prime is awarded. So just wrapping up a little bit on creation of the design build team and the teaming agreement. Some of the factors to consider when putting together the team include the following. The financial stability of the firms. Are they both equally financially stable? Can they support the project through its conclusion? What is their prior experience with the type and size of the project? Do they have enough personnel readily available to work on the project? Are they going to put up key personnel and dedicate them to the project? What's their prior design build experience? And what is their design build philosophy and their philosophy for working together as a team? And what's their track record for doing that? And then what is the familiarity with local codes and requirements? And I've got to tell you, I have been involved in projects where a design build team came in to a part of the country where they'd never worked before, a part of the country where it rains all the time, and they were from an arid environment. And when they started working on construction in the constant rain, it was very difficult for them. They didn't understand the issues they were going to confront. And also they had issues with subcontractors because they were new to the community. They did not have a history of trust with subcontractors, and this became a real impediment to the project. So it's important that if you're going to team with someone, that they know the environment, they have a history performing there, they have contacts in the community, they know good subs to use, trade subs to use, etc. These are all going to be critical to a well-managed project. Then we look at what is an in-house resource available for each of the firms to perform the necessary services. And the workload, do they have the availability of personnel now? And what would be the insurance requirements, and can each of the teammates pull the bonding and the insurance needs necessary for their aspect of the work or the service? And then the acceptable contract terms, allocation of risk. Are the parties willing to negotiate and accept risk appropriate to them, and risk that each of them can manage and insure to the maximum extent possible? These would be some of the considerations that I believe we should be looking at in determining who the design build team will be. Next we'll go to lesson 3. So join me for lesson 3, which will be documenting the agreement between the parties, the agreement between the prime and the sub, and also document the agreement between the project owner and the prime. So join me for that, coming up next.